Hey guys, it's Gary. Last week I promised you there would be more tax problems than there are. Another one's come up here. So, as we discussed last week, this is a time of year where the counties start issuing the tax bills. No rhyme or reason to how they do it. You have some of them that have already come out over the last couple of weeks. Lexington just came out. Other counties, who knows when they'll come out? Richland, nobody knows when they'll come out. And of course, I always wait till like the last day of the month or a Friday to have the tax bills come out. And the reason that's a problem, as I mentioned last week, is once the tax bill comes out, we have to collect it. And so it may change. The tax bill amounts have changed. So let's go back and review something that's very important because this is a big problem that's come up. As y'all know, taxes are we have two different tax rates, 4% for owner occupied, 6% for investment, second homes, rental, things of that nature. As you also know, that it can be a tripling, doubling or tripling of the taxes. So under the CCRA contract, what it says is that the lawyer is to prorate taxes based on the most recent tax bill. That is whether if the tax bills come out, that's the most recent. If it hasn't come out, then you're using last year's tax bill. Under the state contract, it says that the closing attorney is going to use the information that they deemed most reliable. I will tell you that the only information that's truly reliable for a closing attorney is the last tax bill, the most recent tax bill. You can't use tax estimators and claim it as reliable because the county websites always say this is for informational purposes only and not to be deemed reliable. So I don't know how an attorney can deem something reliable when the county says it's not even reliable. Nevertheless, the situation that arose is that the property was being taxed at 6%. The buyer was going to buy the property and then turn it into primary residence, changing the tax rate to 4%. Most counties, though it's not required by law, but most counties, if you change the tax rate during the year, going from a 6% to a 4% sometime during the calendar year, they will give the entire year back at 4%. In this situation, tax was at 6%. The parties agreed in writing that they were going to prorate it at 4%. That was the way the buyer had convinced the seller to sell the property in this tight market. We'll prorate at 4% instead of the 6% because the buyer believed they were going to go change the tax rate. Well, what happened was the tax bill came out. So now what do we do? Because the tax bill, as you know, once a tax bill is issued by the county, it becomes a lien against the property, which has to be paid off at closing. You can't just say, we'll pay it in January. It's got to be paid at the closing because it is now a lien against the property. So in that situation, we had to collect taxes at 6%, but we have an agreement that the parties are going to prorate at 4%. So in order to follow the contract, what we had to do is collect the tax bill, 6% from the buyer, the whole tax bill, which was 3 times what it should be normally for a 4% rate. And then the seller gave a 4% credit back to the buyer. Well, that winds up costing the buyer a couple $1,000s because the tax bill had come out, but that's what the contract said. Luckily, the parties agreed in writing that after the closing, if the rate does change and there's a refund, the refund will go back to the buyer, which is another problem. Nowhere in either contract does it talk about what happens if a refund is issued after closing. If a property bill goes down, it doesn't talk about it because all prorations are final under the CCRA contract. Now, in the state contract, it says the parties will get back together and refigure taxes out. Okay, I hope they will, but there's really no teeth to that. I mean, the lawyer can't make anybody do it. And in CCRA contract, if we have that situation where the tax bill gives a refund, there's nothing in the contract that tells us what to do. So a lot of lawyers like ourselves at Blair Cato, we have people signing a document that says, if there is a tax rate agreement, this is how we want, or a refund, this is how we want to handle it. Most parties just say reprorate it and give the money back. But there's no guarantee they'll send the money back to the closing attorney. They might send it to the seller or the buyer or the lender. So who knows what happens to the tax check then. But the bottom line is what should happen in those situations, if you're going to change how the tax bill is going to be prorated on the closing statement in the contract, you need to go ahead and add the then what. If the tax bill comes out, then this is what's going to happen. Because in this situation, what should have happened is the contract should say tax will be prorated at 4% unless the tax bill comes out. Then it will be taxed at 6%, and the parties agreed to reprorate any refund or however they wanted to handle it. Luckily, this did work out in this situation. But the key here to understand is that tax bill comes out. We got to collect what the tax bill is, regardless of what you said about how we're going to prorate. But you need to address that. If the tax bill comes out, then this is how we'll handle the proration. But you only have to do that. Keep in mind, you only have to do that if you're changing how we're doing it currently under the contract. All right. Hope that helps everybody out. It's a weird tax issue. It doesn't happen too often just this time of year. Hope everybody has a great weekend and see you next week.